E. Forced labor assignments as cruel and inhumane treatment. The trial chamber is satisfied that in violation of the norms of international humanitarian law, civilians were forced to dig trenches, build bunkers, and work on other military assignments on the front line, where they were exposed to dangerous conditions and were under a high risk of being injured or killed. The trial chamber accepts that the acts of forcing civilians to work in life-threatening circumstances fail to meet the obligation for humane treatment of civilians enshrined in the Geneva Conventions and amount to cruel and inhumane treatment. The trial chamber is satisfied that these assignments were made on a discriminatory basis and that they reach the level of seriousness required for persecution. The trial chamber, furthermore, is satisfied that non-Serb civilians were subjected to humiliating forced labor. While single instances of humiliating assignments may not reach the level of gravity required for persecution, the trial chamber accepts that these assignments were part of a pattern targeting the Bosnian Muslim and Bosnian Croat political and economic leadership. The trial chamber is satisfied that the humiliating assignments reach the level of gravity to amount to persecution. The trial chamber accepts that certain types of work that included food preparation, maintaining the water and power supply systems, and agricultural work were necessary for the welfare of the community, and even if compulsory, were permissible under international humanitarian law. It has not been established beyond reasonable doubt that the conditions under which this labor was rendered were such as to amount to cruel and inhumane treatment, or that the assignments are of sufficient gravity to constitute persecution. The trial chamber accepts that the Bosnian Muslims and Bosnian Croats who were forced to loot the houses of people whom they sometimes knew well and highly respected were subjected to humiliating treatment. It is not satisfied, however, that the crisis staff's participation in forcing civilians to loot through the forced labor program has been established beyond reasonable doubt. The trial chamber finds that the Secretariat for National Defense, the body responsible for administrating the forced labor program, was accountable to the crisis staff. Therefore, it finds that the crisis staff was ultimately responsible for sending people to work in dangerous conditions. The trial chamber is satisfied that the dangerous and humiliating forced labor assignments to which Bosnian Muslims and Bosnian Croats were subjected were part of the joint criminal enterprise to persecute non-Serb civilians in the municipalities of Bosanski, Simić, and Ojak. The trial chamber is satisfied that BLAGOJA Simić intended to subject Bosnian Muslims and Croats to dangerous or humiliating work. As the president of the crisis staff and later war presidency, he participated in the appointment and the dismissal of the head of the Municipal Department for Defense. He was aware of the overall situation in the municipality and of the fact that civilians were used for trench digging and other dangerous military assignments. He did not take any measures within his authority to stop this practice. While the trial chamber is satisfied that Miroslav Tadić was aware of the existence of the forced labor program, it is not satisfied that he shared or was aware of BLAGOJA Simić's intent and that of the other participants in the joint criminal enterprise to subject Bosnian Muslims and Bosnian Croats to dangerous or humiliating work. While the evidence supports the fact that Miroslav Tadić was involved in the forced labor program, the trial chamber is not satisfied that he participated in forcing non-Serbs to do dangerous or humiliating work. The trial chamber is not satisfied that the evidence presented supports a finding that Simo ZARIĆ substantially contributed to the dangerous or humiliating forced labor assignments. F. Plunder. The trial chamber accepts that immediately after the forcible takeover of Bosanski Samić, individual looting on a large scale occurred. While it has been established that paramilitaries, individual members of the 4th Detachment, policemen, and ordinary Serb civilians were involved in acts of plundering of non-Serb property, the trial chamber is not satisfied that the role of the crisis staff in these acts has been proved beyond reasonable doubt. The trial chamber accepts the evidence of defense witnesses that some measures were taken by the crisis staff to protect property left behind by individual families or property solely owned by public companies. While the trial chamber accepts that some civilians who gathered every morning in front of the local commune building for their work assignments were involved in looting, it is not satisfied that there is evidence beyond a reasonable doubt that the crisis staff ordered the looting. Witnesses who were forced to loot testified that sometimes they received instructions from Serb civilians who were looting along with them, or from the drivers who were looting for their private purposes, that looted goods were loaded onto private vehicles, and that there was no control of any kind. In view of the above, the trial chamber is not satisfied that the widespread plundering and looting of the property of Bosnian Muslims and Croats was part of the common plan to persecute non-Serb civilians. While the accused's knowledge of the occurrence of acts of looting is not contested in this case, the trial chamber is not satisfied that their intentional participation in any form has been proved beyond reasonable doubt. G. The issuance of orders, policies, decisions, and other regulations in the name of the Serb crisis staff and war presidency. Although the crisis staff of the Serbian Municipality of Bosanski Samić issued some decisions violating the right to equal treatment of non-Serb civilians, the trial chamber is not satisfied that such decisions were of sufficient gravity to constitute persecution. H. Deportation and transfer. The trial chamber is satisfied that non-Serb civilians were deported from the municipality of Bosanski Samić to Croatia and from Batokovići to Lipovac. Other non-Serb civilians were also transferred within Bosnia and Herzegovina, namely from the municipality of Bosanski Samić to Dubica. The trial chamber is not satisfied beyond reasonable doubt that transfers of non-Serb civilians from the municipality of Bosanski Samić to Zazavica and Cerkvina were conducted with the intention to permanently displace them, and for this reason concludes that these non-Serbs were not forcibly transferred. Similarly, the trial chamber is not satisfied that the relocation of non-Serb prisoners from one detention center to another within the Serb-held territory in Bosnia and Herzegovina constituted forcible transfer in the absence of the accused intent that the victims will not return. The trial chamber finds that none of the accused is criminally responsible for forcibly transferring non-Serb prisoners from one detention facility to another, as the trial chamber is not satisfied that the accused had the intent to permanently displace these prisoners. With regard to the criminal responsibility of BLAGOJA Simić, the majority is satisfied that he took part in the joint criminal enterprise to persecute non-Serb civilians by deporting and forcibly transferring them. The trial chamber considered that the crisis staff, of which BLAGOJA Simić was the president, was regularly informed about the exchanges by Miroslav Tadić. On 2nd October 1992, BLAGOJA Simić, as the president of the war presidency, signed the appointment of the Civilian Exchange Committee that reported on its activities on a monthly basis to the war presidency. The trial chamber also considered that the system of exchanges took place over a period of about 1.5 years, and finds that BLAGOJA Simić did not take sufficient measures to prevent non-Serbs from being unlawfully displaced. The trial chamber is satisfied that BLAGOJA Simić was aware of the non-Serb ethnicity of the people who were unlawfully displaced. The trial chamber is convinced that the extensive and continuing mistreatment of non-Serb civilians and their subsequent displacement proves that the participants in the joint criminal enterprise to persecute them had the shared intent to permanently displace them. The only reasonable inference from all these persecutory acts is that the perpetrators intended that the victims should not return. Thus, the trial chamber is satisfied that BLAGOJA Simić had a discriminatory intent with regard to the unlawful displacement of these non-Serb civilians. For these reasons, the trial chamber finds that BLAGOJA Simić participated in the joint criminal enterprise to persecute through deportation and forcible transfer. With respect to the criminal responsibility of Miroslav Tadić, the trial chamber finds that it has not been proved beyond reasonable doubt that Miroslav Tadić participated in a joint criminal enterprise to persecute non-Serb civilians by unlawfully displacing them. However, it is satisfied beyond reasonable doubt that Miroslav Tadić substantially contributed to the deportation of non-Serb civilians as an aider and abettor. Miroslav Tadić was aware that the participants in the joint criminal enterprise to persecute non-Serb civilians through deportation acted with a discriminatory intent. In this context, the trial chamber takes into account that Miroslav Tadić knew of the non-Serb ethnicity of the prisoners in Bosanski Simić, who were later displaced, and he knew about their arrest, detention, and cruel and inhumane treatment in the detention facilities in Bosanski Simić. With regard to Miroslav Tadić's intent to permanently displace non-Serb civilians, the trial chamber does not accept Miroslav Tadić's statements that he never wished that some of his fellow citizens would leave forever and that there was always a possibility to return. The trial chamber is satisfied beyond reasonable doubt that the prosecution has adduced sufficient evidence to prove that Miroslav Tadić had the intent to permanently displace non-Serb civilians from their homes in the municipality of Bosanski Simić. The trial chamber is satisfied that the only inference from his substantial and continuing activity in the exchange of non-Serb civilians is that Miroslav Tadić had the intent that these non-Serb civilians would not return, or that he at least knew that his actions were likely to permanently displace these non-Serb civilians and was reckless thereto. For these reasons, the trial chamber is satisfied that Miroslav Tadić incurs criminal responsibility as an aider and abettor to persecutions through deportation. Turning to Simo ZARIĆ, the trial chamber finds that he, together with Miroslav Tadić and Bozo Ninković, were designated by the crisis staff to be involved in compiling lists with the names of Serbs who were detained in Ojak prior to the exchange in Dubica on 25-26 May 1992. And as he hailed from Černjak Zorice in Ojak municipality and could provide information on many of these detained Serbs. However, the trial chamber is not satisfied that the prosecution did adduce sufficient evidence to establish beyond reasonable doubt that Simo ZARIĆ acted with a discriminatory intent or was aware of the persecutory intent of the participants in the joint criminal enterprise to persecute non-Serb civilians through forcible transfers. The trial chamber is also not satisfied that Simo ZARIĆ participated in the unlawful deportation of non-Serb civilians on 4th and 5th July 1992 in Lipovac. Although the trial chamber accepts the evidence that Simo ZARIќ was present at the exchange site, the trial chamber finds that the prosecution has not adduced sufficient evidence to prove beyond reasonable doubt that Simo ZARIќ's presence or any other activity prior to this exchange constituted a participation in the exchange. Crimes against humanity, deportation, count 2. The trial chamber is satisfied beyond reasonable doubt that BLAGOJA Simić and Miroslav Tadić are criminally responsible for the deportation of non-Serb civilians, a crime against humanity pursuant to Article 5D of the statute, based on the same conduct that constituted the underlying act of deportation under count 1. With regard to Simo ZARIќ, the trial chamber finds that the prosecution has not adduced sufficient evidence to establish beyond reasonable doubt that he incurs criminal responsibility for deportation pursuant to Article 5D of the statute.
Sentencing. The trial chamber now turns to the matter of sentencing. In accordance with the appeals chamber jurisprudence on cumulative convictions, the trial chamber takes into consideration in the determination of sentence that convictions for different crimes under the statute based on the same conduct are permissible only if each crime involved has a materially distinct element that requires proof of an element not contained in the other. Where only one of the crimes contains a materially distinct element, the chamber must enter a conviction for that crime only, as being the more specific one. While the crime of deportation as a crime against humanity does not contain a materially distinct element from the crime of persecution, persecution requires the materially distinct element of discriminatory intent. The trial chamber therefore finds that cumulative convictions for deportation as a crime against humanity and persecution through deportation are not permissible and enters a conviction for persecution only as being the more specific crime. The trial chamber has therefore convicted Dr. BLAGOJA Simić of crimes against humanity for persecutions based upon unlawful arrest and detention of Bosnian Muslim and Bosnian Croat civilians, cruel and inhumane treatment including beatings, torture, forced labor, assignments, and confinement under inhumane conditions, and deportation and forcible transfer in count 1. On the basis of cumulative convictions, no conviction is recorded for count 2. Miroslav Tadić is convicted of crimes against humanity for persecutions based upon deportation and forcible transfer in count 1 and on the basis of cumulative convictions. No conviction is recorded for count 2. Simo ZARIĆA is convicted of crimes against humanity for persecutions based upon acts of cruel and inhumane treatment, including beatings, torture, forced labor assignments, and confinement under inhumane conditions in count 1. With regard to Dr. BLAGOJA Simić, the trial chamber considers his position as a leading member of the joint criminal enterprise, whose purpose was to take over power in the Bosanski municipality and to remove the Bosnian Muslims and Bosnian Croats from this territory through heinous persecutory acts as an aggravating factor. Moreover, the trial chamber emphasizes that as the most important civilian leader in the municipality, Dr. BLAGOJA Simić had a particular responsibility towards the entire population. The trial chamber also accepts that the victim's vulnerable position as held in detention and the fact that as a medical doctor, Dr. BLAGOJA Simić was well aware of their sufferings constitute an aggravating circumstances. As mitigating factors, the trial chamber accepts BLAGOJA Simić's voluntary surrender to the custody of the tribunal, his general comportment towards the proceedings, good conduct in detention, and clean criminal record. With respect to Miroslav Tadić, the trial chamber takes into consideration his active role in the process of exchanges and the status of the victims, whom due to the fact of their detention and other circumstances, were not able to make a genuine choice regarding their exchange. The trial chamber accepts as mitigating factors the fact that Miroslav Tadić helped some Bosnian Muslims during the war, his voluntary surrender to the tribunal, his remorse, and his personal circumstances, as well as the lack of prior convictions. Regarding Simo ZARIĆA, the trial chamber finds that his role as an active member of the 4th detachment, his position of power, and the status of vulnerability of the victims who were subjected to regular mistreatment in detention constitute aggravating factors. The trial chamber accepts as mitigating factors his attempts to alleviate the suffering of some of the victims and his attempts to take measures against some of the crimes, his remorse, voluntary surrender, personal conditions, and lack of prior criminal convictions. The trial chamber now delivers this disposition. The accused, Dr. BLAGOJA Simić, will you please stand up? With respect to you, Dr. BLAGOJA Simić, a conviction is entered for count 1, crimes against humanity, for persecutions based upon lawful arrest and detention of Bosnian Muslim and Bosnian Croat civilians, cruel and inhumane treatment, including beatings, torture, forced labor assignments, and confinement under inhumane conditions, and deportation and forcible transfer. No conviction is recorded for count 2, as the trial chamber finds it to be impermissibly cumulative with count 1. Count 3 is dismissed due to defects in the form of the amended indictment. Pursuant to Rule 101C, following your voluntary surrender to the custody of the tribunal on 12th March 2001, and your subsequent detention at the tribunal's detention unit, you, Dr. BLAGOJA Simić, are entitled to credit for 949 days towards service of the sentence that will be imposed, together with the period you will serve in custody, pending a determination by the President pursuant to Rule 103A, as to the state where the sentence will be served. You are to remain in the custody of the detention unit until such determination is made. Dr. BLAGOJA Simić, you are sentenced to a term of 17 years imprisonment. You may sit down. Mr. Miroslav Tadić, please stand up. With respect to you, Miroslav Tadić, the trial chamber enters a conviction for count 1, crimes against humanity for persecutions based upon deportation and forcible transfer. No conviction is recorded for count 2, as the trial chamber finds it to be impermissibly cumulative with count 1. Count 3 is dismissed due to the defects in the form of the amended indictment. You, Miroslav Tadić, you are entitled to a credit for 1,568 days towards service of your sentence, together with the period you will serve in custody pending determination by the President pursuant to Rule 103A as to the state where your sentence will be served. You are to remain in the custody of the tribunal until such determination is made. You, Mr. Miroslav Tadić, are sentenced to a term of imprisonment for 8 years. You may sit down. Mr. Simo ZARIĆA, please stand up. With respect to you, Mr. Simo ZARIĆA, the trial chamber enters a conviction for count 1, crimes against humanity, for persecutions based upon cruel and inhumane treatment, including beatings, torture, and confinement under inhumane conditions. The trial chamber acquits you of count 2. Count 3 is dismissed due to defects in the form of the amended indictment. You, Simo ZARIČ, are entitled to credit for 1,558 days towards service of your sentence that will be imposed, together with a period you will serve in custody pending a determination by the President pursuant to Rule 103A of the statute as to the state where your sentence will be served. You are to remain in the custody of the tribunal until such determination is made. Mr. Simo ZARIČ, you are sentenced to a term of imprisonment for 6 years. Will you please sit down? Judge Lindom will pronounce his conclusions according to his separate and partly dissenting opinion.
Your Honor, as said, I will only read out the disposition contained in my partly dissenting opinion. In agreement with the considerations of the trial chamber regarding cumulative convictions, I agree with the majority's conviction of BLAGOJA Simić on count 1, persecutions as a crime against humanity. For the reasons I have given in my partly dissenting opinion, I find a sentence to 7 years imprisonment proportionate and just. I further find that Miroslav Tadić and Simo ZARIČ are not guilty of count 1 and count 2. I concur with the majority in dismissing count 3. Thank you.
These proceedings are now closed, and the court will rise.
All rise, we will obey.